Ken Himmler, and I'm reaching out to you in my drive time, and I want to talk to you about what's happening with the upcoming tax law changes. Every president that comes in requires that we completely reconfigure every possible tax plan that has been created for you. This year is no different. What I do see on the economic forefront is that under this new administration, the IRS is going to be in a whole different position, which I'll explain in another video. Today, it's really about the tax plan itself and what you do as far as your estate plan, because again, in 2026, the estate plan limit is set to expire and come back to $5 million. And remember, that's $5 million in total assets: house, car, wedding ring, watch, clothing, furniture, IRAs, everything together. That if you exceed that, then they're going to impose a estate tax. But let's not forget about the state estate tax. I know that gets a little wordy, but each state either elects in or out of a state-based estate tax. I was primarily talking about a federal estate tax. And depending on where you live, I mean, if you live in Oregon, there's a $1 million limit, and that includes everything. So if your house is worth more than $1 million, even though you might be out of the throes of the federal estate tax, it does not exclude you from the state estate tax. Those are all things that are changing this year. Another big one is a lot of the changes with your retirement plan, your IRAs, your 401ks, Pension Protection Act, or I'm sorry, the Secure Act. Get my all these federal laws. These congressmen have to justify their existence. So obviously every year they've got to come up with 500 new laws. I know that's me being sarcastic, but the Secure Act 2.0, which was passed in January of 23, is going into full force next year. So those of you that have IRAs and 401ks and all of the estate plans that were done behind that. Now, if you're a client of ours, you've heard us beat the drum that you should never, ever have a human named as the beneficiary of your retirement plan. Well, under Secure Act 2.0, it's even more important that you do not name a human as the beneficiary. There is something called a IRA standalone trust. And while a lot of financial advisors and CPAs don't even know what this is important so that if something ever happens to you and your intention is you want those assets to go directly to your beneficiaries, if you have a human as a beneficiary, it might be lost through death, divorce, disability, and even lawsuit. So under the new Secure Act 2.0, it's even more imperative than ever to make sure that you do not have a human named as a beneficiary and you have your IRA sat. Now, for those of you that are clients of ours, and we've already drafted those IRA sats for you under Secure Act 2.0, guess what? We're going to have to redraft them because a lot of stuff have changed. Lastly, under a lot of the things that we did for you, if you're a client of ours, if you didn't, this is good information. And if we tried to use a land trust for your home in between your family trust and or in between an LLC, those things have changed too. And now, in order to preserve your tax base and in order to preserve your $500,000 existence of, so you sell your house and you get $500,000 of tax exemption, a lot of your land trusts are also going to have to be changed and altered to comply with the new rules. So, real short, I'll be reaching out. Well, I shouldn't take the credit for it. If you're a client of ours, our team will be reaching out to you and scheduling an appointment to go through some of all these changes that I just talked about. Hey, with that in mind, have a great day.